Hello, my name is Alina and I'm a researcher in international insolvency law, and as such I would like to use this very cake in order to explain what tax payments in international insolvency situations are all about. When I bought this cake, I entered into a purchase agreement with the bakery, and the purchase price included a portion for taxes, the value-added tax, short VAT. Now what happens when a business like a bakery collapses? So imagine that I'm not an ordinary customer, but a German company that operates a logistics center in Poland and therefore paying taxes to the Polish state. That situation might seem a little bit different, and the question arises, what happens to the tax payments that go to the Polish state if the company falls into insolvency in Germany? This is exactly what happened in a case that is currently up for decision before the Court of Justice of the European Union. A German company has become bankrupt and filed for insolvency in Germany. The insolvency administrator then contested two payments totaling to an amount of 5.7 million zlotys. However, the German courts decided that they could not rule upon this matter because of the principle of sovereign immunity. This principle has been established with the end of the 30 Years' War. It states that states do not sit in judgment over one another. Collecting taxes is widely recognized a sovereign act, but are insolvency claims that relate to tax payments also a matter of sovereign immunity, hindering other European courts to rule upon such matter? There's solid ground to argue that insolvency claims are not protected by sovereign immunity, because insolvency claims are a private law matter. Additionally, there's a principle in German insolvency law that dictates that all creditors shall be treated equally. Take this cake, for example. If one creditor were to take away the biggest piece of the cake only shortly before the company goes bankrupt, there would be little less for all the other creditors, and no creditor shall be privileged over the other. But there is an alternative way to resolve this dispute with regard to the EU Insolvency Regulation. Pursuant to Article 6, subsection 1 of the EU Insolvency Regulation, the courts of the member states in whose territory the insolvency proceedings have been opened have the jurisdiction over all issues arising out of the insolvency proceedings. This could be interpreted as an implied waiver of the EU member states' respective sovereign immunity. And I want to give you 5 reasons for this interpretation. First, Recital 63 states that any EU creditor has the right to lodge his claims in any proceeding pending in other EU member states, including claims against tax authorities. Second, when it comes to definitions, Article 2, subsection 12 states that the term foreign creditor shall also apply to tax authorities, meaning that no distinction shall be drawn between creditors acting under private law and creditors acting under public law. Third, tax liabilities may also be included in a restructuring plan pursuant to Article 56 of the regulation, and such a plan has to be recognized by all the EU member states, even if it reduces the tax liabilities. Fourth, Article 16 of the regulation sets some limits to insolvency and borders. It does, however, not address any tax-related issues. If the legislator had wanted that, it could have easily implemented such a provision. And lastly, the FAUTIR demands that European legal texts are interpreted in such a way as to give them the greatest possible effect. Now, putting all this together, it is very likely that the Court of Justice of the European Union will find that the principle of sovereign immunity does not apply and that German courts can decide upon this matter. The decision will therefore set the course for all tax-related insolvency matters all across Europe. And it also shows that we have to further harmonize the European insolvency law. And while we wait for what happens in Brussels and Luxembourg, we can at least have cake.